on the second event, because there's no bullet holes that's been shown in the windshield, only in the back glass.
Joining us now in Phoenix, Arizona, former criminal defense attorney who represented Jodi Arias, Kirk Nurmi. Kirk, always great to have you on. Thanks for joining us. Are you surprised in this hearing that the judge denied and said, nope, no immunity, you go to trial?
Great to see you, Ashley. No, I'm not surprised at all, because I look at a hearing like this, the odds of the defense prevailing when the burden of proof is on them are slim. So, but obviously the defense wants to go forward. They have nothing to lose, explore this information, possibly get the case dismissed. But the ultimate decision, and especially when we've just heard those arguments, actually, I think there's valid arguments on both sides. I think the hill would be too hard to climb for this defendant to receive the kind of immunity at a hearing like this.
And are you surprised? I know that I've talked about the fact that this defendant did not testify at this particular hearing. And just a reminder to our viewers, this was not a criminal trial. This was a hearing before the court to determine whether or not the defendant would be immune from prosecution because of the stand your ground law in the state of Georgia. And the court said, nope, he can go to trial. Are you surprised this defendant did not testify at a hearing of this nature?
Not at all, Ashley, because you wouldn't want sworn testimony of that nature to be held against him later at trial. Given what I said earlier, with the odds of victory are slim, I don't think that his testimony really could have got him over the hump into the point where the fact that the judge would grant immunity. So he's better off holding back so the state of Georgia is not prepared for what he has to say, so he can come on the stand as a clean witness without giving the state any ammunition to impeach him with, should he choose to testify at trial.
That's right, because it can be used against him at trial if he had chosen to testify. Kirk, I'd like to look together. I think we have a full screen of the truck and the individuals that were in that truck, because we know there were 5 individuals in that truck. Mason, who was the driver of the vehicle, Ashton, the passenger in the front seat, passenger, can't speak today, Macy in the back, Luke in the back, and then in the middle we have Haley Hutchison, who we know was hit in the back of the head with a bullet from the gun that was fired by the defendant in this case. So on one hand, we have these 5 individuals in that truck, and I think we can presume that 4 of those are going to be witnesses in that criminal trial. On the other hand, Kirk, we know that we have the defendant in the other car and his girlfriend, Emma Rigdon, who did testify during this hearing. Is this case going to really boil down to he said, she said involving these 6 individuals?
Certainly, that's going to be a lot of the testimony, right, Ashley, in the believability of all of these individuals involved. But of course, as you just pointed out when we talked about the bullet and where the bullet hit this victim, the decedent, that's going to play an important role as well, because the logistics of the reasonableness of stand your ground. We heard the prosecutor in this closing arguments in this hearing talk about stand your ground doesn't mean pursue. And I think that's going to be an important aspect of this trial, because what exactly was the trajectory of the bullet? Were they straight in front of him? What was happening beforehand? You know, not only in terms of the racial slurs, but what about the driving? Are there witnesses to the driving that can attest to this truck driving erratically or in a way that would put the person, in this case, Mr. Wilson and his girlfriend, in danger? Because I think that's really going to be the crux of the case. The fact that the bullet came in from the back, to me, is not completely dispositive, because someone could try to run someone off the road and still wind up in front of them.
Right, but it's a good point. They'll look at all the forensics that go into preparing for a trial in the course of the investigation leading up to that point. Kirk, the other thing I want to talk about, and as a former judge, this piece really bothers me for any criminal defendant, and that is, we know since 2020, this man, this defendant, really young, has been in jail. There was no bond order issued after a request to reduce bond. He's been held without bond until today. So he's been in jail since 2020. Let's look together at the different bond conditions granted today following this hearing. The judge ordered a $100,000 bond. $20,000 of that at least has to be in cash. The other can be a property bond. House arrest on an ankle monitor within 25 miles of his father's home, radius of his father's home. He cannot use social media, and not surprisingly, no contact with the victim's family or witnesses, which is a very common term of bond. What do you think about this particular, the elements of the bond granted by the court today, knowing that although requested, there was never an order granting or denying a request that he be allowed on bond, consequently 2 years in jail since 2020?
Yeah, well, it's certainly repugnant to everything the American criminal justice is standing for. The idea of innocent until proven guilty. Mr. Wilson has really been housed as a guilty man with no opportunities to challenge the presumption of guilt that seems to be imposed upon him at trial. So it's certainly repugnant to any sense of justice in that regard. Now, as far as the conditions go, I think the conditions go, given the charges and everything, seem fairly reasonable to me now that it's been granted. But ultimately, this bond, I think, Ashley, this reasonable bond came 20 months too late.